You go to refinance, or you're getting ready to sell, and the title company calls with two words that stop you cold. There's a lien. Your HOA has recorded a claim against your home over unpaid dues. Here's what most homeowners don't realize in that first panicked hour. A lien is not the same as losing your house, and it is not the end of the story. It's a legal marker that the association has to have put there correctly, and there is a clear, orderly way to deal with it. So let's walk it. What a lien actually is, how it landed on your property, what to do about it step by step, and how to tell a valid lien from one you can challenge. Start with what this thing even is, because the word lien sounds scarier than the mechanics are. It's a legal claim your association attaches to your home as security for money it says you owe, and it doesn't stop at the missed dues. In Florida, for example, the statute lets that claim sweep in the interest, the late charges, the collection costs, even the association's attorney fees. Here's the part that catches people off guard. In a lot of states, the right to a lien is baked into your governing documents from day one, so it can attach almost automatically and even relate back to the date the community was first recorded, meaning it doesn't just appear the moment they file paperwork. But it only becomes a public cloud on your title once they actually record a claim of lien down at the county. That recording is the event that shows up when you sell or refinance, and it's also the event the law surrounds with rules, which is exactly where your leverage lives. Now trace how it actually got there, because every arrow on this chart is a step the association had to take in order, and a step it can get wrong. It starts small. One missed payment, and the meter starts running as late fees and interest stack onto the balance. But look hard at step 3, because this is the one homeowners forget they're owed. Before the HOA can record anything, most states force it to send you a written pre-lien notice or demand first. California gives you 30 days by certified mail, Florida 45 days. Texas actually requires 2 separate notices before it can file. That notice isn't a courtesy, it's a legal prerequisite. Only after that clock runs can they take step 4 and record the claim at the county. So if a lien showed up and you never got a proper warning shot, the association may have skipped a rung. And that skipped rung is the first thing worth checking. Take the fear seriously, but put it in the right box. The real, immediate bite of a lien is that it clouds your title, and a clouded title quietly blocks the 2 things you might most want to do, sell or refinance, because no title company will close over an unresolved claim. That's why some people only discover the lien years later at the closing table. Now the part that should lower your blood pressure. A lien is not a foreclosure. It's the legal foundation the HOA would need before it could ever try to take the home. But foreclosure is a separate, much slower road, and several states put real guardrails on it. California, for instance, won't let an association foreclose an assessment lien unless the underlying debt has hit $1,800 or is more than 12 months past due. If you've heard our foreclosure episode, this is the step before that, and handling the lien now is exactly how you keep it from ever becoming that. This is the spine of the whole video, so walk it in order. Each step protects the next. Notice steps 1 and 2 come before you pay a cent. You get the numbers in writing, and you check both the math and whether they followed the process. Step 3 is where your leverage turns into action. You dispute in writing, never over the phone, because a paper trail is the only thing that survives a memory. Step 4 is the one proud homeowners skip. Ask about a payment plan early, before interest turns a small balance into a foreclosure-sized one. And burn step 5 into your brain, because it's the mistake I see most. Paying is only half the job. If you pay and never confirm a release was actually recorded at the county, the lien can just sit there clouding your title for years. Get the release in writing, recorded. That's the finish line, not the check. Let's slow down on the first 2 steps, because this is where cases are quietly won. Do not accept a round number. You owe $2,000 is not a payoff, it's a guess you're being asked to fund. Demand it itemized. Every assessment, every late fee, every interest charge, every so-called cost, broken out line by line in writing. California actually requires that itemized statement, and it spells out something powerful. If it turns out you paid the assessment on time, you don't owe the collection charges piled on top. So run the ledger against your own bank records. People find payments that were misapplied or double counted all the time. Then verify the process itself. Did that required pre-lien notice actually go out to the right address with the right lead time? A lien built on a skipped notice is a lien standing on a crack, and you can't see the crack until you ask for the paperwork. Here's a lever a lot of homeowners never pick up. The moment your HOA hands the file to a collection agency or a law firm, federal law joins your side of the table. The Fair Debt Collection Practices Act treats those third-party collectors as, well, debt collectors, and that gives you the right to make them validate the debt. If you dispute it in writing within the window they're required to give you, they generally have to pause collection until they actually verify what you owe. So don't argue on the phone where nothing is preserved. Put it on paper and be specific. Not "this is unfair," but "my March payment was applied to the wrong account," or "this fee isn't in the schedule," or "this is a fine, and in my state a fine that size can't even become a lien." A precise, written, dated dispute forces the machine to stop and prove its case, and half the time, once someone actually checks, the number shrinks. Paying is not the finish line. The recorded release is. In California, the association has just 21 days after you pay to record that release and hand you a copy, and other states set their own clocks. But do not take "yeah, we took care of it" as proof. Liens live in the county land records, and a phone assurance doesn't clear a record, only a recorded satisfaction does. So a few weeks after you pay, go pull it yourself, or have the title company confirm it's gone. Otherwise, you'll relive this exact nightmare at your next closing. And know your ceiling. If the balance is large, if anyone has said the word foreclosure, or if you genuinely believe the lien is improper, that's the point to stop DIYing and call a real estate or HOA attorney. One consultation is pocket change next to the house, and a faulty lien, once proven, has to come off along with the fees riding on it. Now the part with teeth. Not every lien is a good lien. The strongest challenges aren't about whether you feel the dues are fair, they're about whether the association followed the rules, because those you can prove with documents. First, notice. If that required pre-lien warning never went out, the lien may be defective from birth. Second, the amount. If it's padded with fees that aren't in the published schedule or your governing documents, the excess is vulnerable. Third, and this one surprises people, some states flatly forbid turning a fine into a lien. Florida says in black and white that a fine of less than $1,000 may not become a lien against a parcel. So if your lien is really just stacked fines, it may not belong on your title at all. And fourth, plain procedural defects. Wrong owner named, wrong parcel described, or filed before the notice period even ran out. Any one of these can be the thread you pull. Run your eye down this table and a rule of thumb jumps out. The left column is about substance the HOA got right, and the right column is about steps it got wrong. And notice which side you can actually fight on. Every challengeable item is something provable on paper, not a matter of opinion. A lien for real unpaid dues, correctly noticed and correctly calculated, is one you deal with by paying or arranging a plan. But a lien with no notice, with a misapplied payment buried in it, with fees that aren't authorized, that's really just fines in a state that bars fine liens, or that names the wrong parcel. That's a lien you contest, not one you quietly fund. So before you write the check, ask which column your lien lives in. The answer changes your entire move. Most of the real damage isn't done by the lien itself. It's done by how people react to it. Ignoring it is the classic. The balance quietly compounds, and a lien you could have cleared for a few $100s becomes a foreclosure-sized problem. The sneaky one is paying and walking away. If you never confirm a recorded release, you fix the debt but not the title, and it comes back to haunt you at the worst possible moment. Then there's the deadline. Those federal dispute rights only work if you use them in writing and on time. Miss the window and you lose the built-in pause that made the collector stop and prove the debt. And the quiet killer is arguing on the phone. A friendly call feels productive, but it preserves nothing. The homeowner who wins is the one with a folder, dated letters, the itemized ledger, proof of every payment. Boring beats loud every single time. There's a line where doing it yourself stops being thrifty and starts being risky, and you want to see that line before you cross it. If foreclosure is on the table, if the balance is large, or if you're genuinely convinced the lien is improper, get a real estate or HOA attorney involved. The underlying asset is your home, and that changes the math on a consultation fee. If the collector has been abusive, calling at all hours, threatening things they can't do, the Fair Debt Collection Practices Act doesn't just protect you, it lets you sue and potentially recover damages plus your attorney's fees, which tends to get a collector's attention fast. And manage your expectations about the state complaint everyone imagines. A handful of states have a real HOA regulator, but many have no agency that will investigate this kind of dispute at all. So find out what your state actually offers before you pin your whole plan on a form. So take these with you. First, reframe it. A lien is a legal claim you resolve, not the loss of your home, and you have far more room to maneuver than that first phone call made it feel. Second, get organized before you get emotional. Pull the itemized payoff in writing. Check both the numbers and whether the required notice went out, and put every dispute on paper. Third, remember that paying is only half the job. Chase the recorded release until you've seen it with your own eyes, because an uncleared lien is a future closing that blows up. And last, know your grounds to fight. Improper notice, padded charges, a fine that can't legally be a lien or a paperwork defect, and the moment foreclosure enters the conversation, bring in a lawyer. Do that, and you go from a homeowner blindsided by a title report to one who knows the rules better than the board that filed against you. This video is general education, not legal advice, and the rules around HOA liens, the notice you're owed, the deadlines, the fee limits, the release timeline, and when an association can foreclose vary by your state and by your community's own governing documents. It was researched and produced with AI assistance, including script research, voice, and on-screen graphics, and reviewed by a human against the cited sources before publishing. Before you act, read your own CC and Rs and bylaws, check your state's HOA statute, and if the balance is large or foreclosure is on the table, talk to a licensed real estate or HOA attorney in your state.